Hey everyone, it's James Younger here from TempStars, doing our very first Instagram live broadcast. Welcome and thank you for tuning in. I think we've got a great interview coming up with Stuart Rudner from Rudner Law and his associate lawyer, Nadia Zaman. She's going to be joining us first. In speaking with colleagues and friends and dentists who have had to close down their offices during the Instagram, the coronavirus pandemic, there's a lot of questions surrounding layoffs and employment situations and responsibilities, obligations, and it's a constantly evolving thing with the government making new announcements and things like that. So I thought it would be great to connect and interview a useful resource, a valuable resource like Stuart and his associate, to just sort of maybe clarify some gray areas, discuss obligations and expectations and things like that. So we'll be introducing them in a minute. Nadia is going to start off and then Stuart will be jumping in later. And we will have a question and answer period. That I hope we get to all your questions, but if we don't, what we're going to do is once we post this to our social, we're recording it, and we'll try to add in the answers to questions that we didn't get to during the live stream. One of the things to know as well, and Stuart and I discussed this, is as you know, TempStars serves the entire dental profession. Whether it be dentists or office managers or hygienists and assistants, we value all as members of the dental profession community, and to us, they're all our members and colleagues. And likewise, Stuart serves both employers and employees. He helps represent both. So we really, during this interview, we had discussions about that where we're really not slanting towards giving interview advice to employers or employees, but really just trying to get the clarity and the information out there for everyone. And the better information that's out there, the better decisions everyone can make. So I hope everyone enjoys. This is my first Instagram live broadcast, so hopefully we don't run into any technical glitches. I'm not an expert at this, but I'm going to try to add Nadia to it. If we do run into something where I have to turn the feed off, we will immediately turn it back on if we run into a glitch and come back to it. So a little patience if you can. 1 minute here. Here we go. So Nadia should be joining us in a minute. So she's an associate, and Stuart and Nadia, they specialize in employment law. And they have a vast number of dental clients, and so they're very knowledgeable about that space and that kind of thing. Hey, Nadia, how are you?
Hi, James. I'm good. How are you?
Good. Thank you for joining.
Thank you for having me.
And you can hear me okay? Okay, fantastic. So, Nadia, tell us a little bit about just your background. How long have you been with Rudner Law, your background in law, how long you've been practicing in employment law, and your experience with dental offices and things like that, if you don't mind just giving us a little background.
Yeah, for sure. So I have been with Rudner Law since 2016, so
Okay.
it's years, and I was called to the bar in June of 2016. I graduated from the University of Toronto Faculty of Law. And I am very passionate about employment law when it comes to representing employers, when it comes to representing employees as well. In particular, our firm, Rudner Law, we have special expertise working with dental offices from the employer side, but also from the employee side. And, we even have materials, education materials that we provide, which is specifically relating to the dental office.
Nice. So if we don't mind, we can just kind of get into the interview here and some questions, but what prompted this? And kind of, there's a few things that just happen to be on every dental professional's mind right now, but if we just walk back a little bit, around March 15th, essentially, is when the RCDSO started mandating offices to provide emergency-only procedures, but also, of course, the requirement for the protective equipment and things like that, meaning a lot of dental offices needed to shut down and advise the team that there would be layoffs and those sorts of things. So maybe if we can step back in terms of, there's probably, I'm going to guess, 3 different maybe broad scenarios where a office has had to advise the team about layoffs, and one would be maybe some of the people on the team have contracts, maybe some of the people on the team don't have contracts, or dental offices don't have employment contracts, and there might be some where they have employment contracts, but maybe you can also speak to best practices to what would be in employment contracts that can address situations like this.
Yeah, for sure. So I know that Stuart might cover this in more detail when he speaks, but with respect to temporary layoffs, a lot of people simply assume, obviously, clinics and dentists are accepted to that. A lot of people simply assume that there's an automatic right that employers have to lay off employees, but this is not true, and this is a common misconception. A lot of people are also, we're receiving a lot of questions from dentists and other dental professionals saying, okay, am I going to have this right to just simply lay off? And if I don't, how does it even make sense? Because all my colleagues are doing it.
Right.
So what we're telling people is that, there's a difference between what people are doing and what they have a legal right to do.
Mm-hmm.
So our job as, the trusted legal advisor is to make sure that we are making our clients and others aware of the risks involved and the ramifications involved with it. So if the contract doesn't have a temporary layoff provision in it, then the employer doesn't have an automatic right to temporarily lay off an employee.
Okay. Now, is there, and I guess maybe we should just, of course, premise all of this with none of this is specific legal advice, and of course consult your employment lawyer and things like that. We're talking general information. And I certainly know dentists in general are getting better about having employment contracts, but if there's no contract in place, and I'm guessing it defaults to some sort of common law situation, what are the obligations under those scenarios?
Yeah, so that's a great question. So I guess we can talk about it from the, dentist or owner perspective versus an employee perspective, whether it's, a dental hygienist or an assistant or office manager. So from the business owner or dentist perspective, the first thing to consider is whether you even have the right to lay off in the first place. And one of the things that we have assisting our clients with is to ensure that if there wasn't a clause in their contract, or if there's no written contract in place, and if there's no sort of right to temporarily lay off the employees, then in that case, ask the employees for their agreement. So ask the workers for their agreement to be temporarily laid off. And an agreement in place, laying out their rights and obligations and requesting them to accept that.
Right.
If employee, let's say, refuses to accept it, or if an employee, a dental hygienist or office manager, if they find that they're being temporarily laid off and it's imposed upon them as opposed to something that's being requested of them, in case there could be a potential constructive dismissal claim. And constructive dismissal, it's similar to wrongful dismissal. Instead of being terminated from your employment, essentially it's when an employer makes a unilateral, substantial change to a fundamental of your contract.
Right.
In that case, your entitlement to damages, if you succeed with that type of a claim, would be similar to the damages that you would otherwise receive if you had been terminated from your employment outright.
Right, I see. Okay. And so there's definitely ways to navigate that. Yeah.
It's a tricky area to navigate, and a lot of people think that they can simply refuse work, or they can simply refuse to accept the temporary layoff, go off and bring like constructive dismissal claim, and that all of a sudden they're going to be entitled to a significant amount of damages. That's not true either.
Right.
But thing that you need to consider and specific legal advice, because every situation will be different.
Yeah. Okay, that's a really good point. Now, I just want to address people watching and listening. It sounds like we've got a couple comments that the audio might be cutting in and out. Nadia, I'm not sure on your end it seemed like I can hear most of what you're saying, but there's a couple little clips where your audio was cutting out. But I also,
Okay.
we're going to be reposting this entire video as a recorded video. So if there's any parts that anybody missed, you'll be able to watch the entire thing as a recording later on once we post it onto our social. So if there's
Okay,
anything missed
great.
about that, yeah.
And for those people who had trouble hearing me, is it better now? If you could just comment saying whether or not it's better, that would be great as well.
Yeah, that was pretty clear, and it was only happening occasionally, but I think it's going to be okay. And like I said, the recording is probably picking it up. And we got a thumbs up from.
Okay,
yeah,
great.
We got a few thumbs up about your audio now. Oh, more thumbs up. Perfect.
Great.
Now let's talk. If we are thinking about those three scenarios, and there are employment contracts. When you and I were talking yesterday, I guess there are certain clauses that, even with contracts, ideally should be in there that address things like temporary layoffs and that sort of thing.
Yeah, no, for sure. So there is a temporary layoff provision that contracts can include, and it's actually interesting because and Stuart, he would definitely agree with me on this, but when we represent businesses, whether it's dental clinics or some other type of business, we usually discuss with them and see whether it might be appropriate to include a temporary layoff provision. And in a lot of circumstances, our client will say to us, well, we've never done that before. I mean, it's a possibility we might need to do it, but we've never done it before.
Mm-hmm.
And our response usually is, if it is appropriate, it might make sense to include it.
Mm-hmm.
And obviously no one anticipated this type of a situation, but this is the perfect example of a situation where, our clients who have had that provision in their agreement, and let's say that the employee, whether it's, a dental hygienist or assistant or some other type of employee, they actually accepted it. In that case, this situation is a much smoother process than it would otherwise have been without that provision in place.
Right. Okay, nice. And then obviously that third bucket where if there are employment contracts that address that, then it just unfolds according to as specified in the employment contract with those clauses.
Exactly.
Yeah. Okay, nice. Now, I guess if we move along in the process, and what's on everyone's mind is, so now dental offices are closed down, their teams have been laid off and things like that. We'll say before that announcement by the government about the wage subsidy, what are the ongoing, I guess, communication expectations between an employer and an employee, and in terms of maybe notifying about recalling people to work and the obligations on the terms of, or expectations on terms of the employees of returning to work and things like that?
Yeah, so that's a great question. So the best practice from the dentist perspective or the business owner's perspective would be to let your dental hygienist or any other employees know as soon as possible. So if you know that they are going to be returning to work even in like 2 weeks time, and if you know it now, it would obviously be better to let them know sooner rather than later, because everyone right now is in this vulnerable situation that they're in, and all sides should cooperate and come to a resolution that works for all parties involved, obviously keeping in mind their rights and obligations. So the best practice would be to let them know as soon as you're aware. When it comes to the dental hygienist or other employee working at the dental office, if the dentist recalls you back to work, so technically there's the expectation that when you are recalled back to work, that you're going to return on the date that you've been asked to return on. And even during the temporary layoff period, if there is a temporary layoff period, the expectation is that the owner is going to call you back to work when there's work available. So even if they say that the temporary layoff is going to last for 2 weeks or 3 weeks or for an indefinite period of time, they could say, and they could specifically include wording to say that during this time you're going to be expected to work as needed if there's
Right.
available. So in that case, that would be the expectation and the understanding between the parties. But a lot of this is sort of colored with the whole COVID-19 situation, because what we have right now is this concern that a lot of people have with respect to the safety aspect of the work.
Of course.
So and you know, the college has also mentioned this, and this is exactly why the only emergency services are being asked to perform at this stage, and not any kind of elective services, and it's because of the safety risks.
Right.
So employees do have the right to refuse unsafe work, but that has to be based on some kind of a legitimate or reasonable ground. So
right.
if you are a dentist and you asked, let's say a dental hygienist to return to work on X date, and they're simply refusing to work but not really providing any reasons and just saying that I don't feel safe, then that might not be enough, and you could actually treat that as abandonment of employment or treat it as resignation, and the whole issue, the termination of the employment might not even arise.
Right.
You might not even have to consider that at all. Obviously, every situation is different, but that's definitely a possibility. From the perspective of the worker, so let's say you're a dental hygienist and you are genuinely concerned because of, the safety reason. So it could be that you're aware that another coworker of yours has COVID-19 related symptoms,
right,
and you're being asked to work in close proximity with them, or you're aware that the sanitization measures are not as strong at the workplace
as it should be.
About that, exactly. So that could be a concern as well. And one of the things that we're probably going to see a lot of is people who are concerned about their family members who may be immunocompromised. And in that case, one of the protected grounds under the code might actually be engaged as well. So the Human Rights Code protects employees against discrimination based on various protected grounds. And one of them is family status. Another one is disability. And there's many others. But these grounds could actually be triggered if a worker is concerned about that.
That's a good point. I even just yesterday, when we sort of made the announcement we were going to be doing this interview, I got an email, and this person was sort of experiencing some symptoms themselves. They were an employee of a dental office. They were in self-isolation, and they were waiting until, I think, tomorrow before they were getting the nasal swab. But I think the dental office where they worked at was one of the ones open for emergency care, and they were saying, come back to work, and if you can't come back to work, we have to find someone else. But I think even in that situation where a person maybe isn't feeling unsafe in terms of working at the office, but maybe personally doesn't feel safe about going into the office because of their own symptoms and situation. Oh, okay. How's that? Can you hear me okay there? I'm not sure. Can someone give me a thumbs up if they can see me? I see Nadia's frozen, but am I frozen as well? Tell you what, oh, you can hear? Okay, thank you. All right. Oh, it looks like Nadia's gone. All right. I've sort of been keeping an eye on the comments coming through. I know these are difficult waters to navigate. And again, I sort of went into this with the realization that sometimes there are these gray areas that are a little tough to navigate. So I appreciate your patience with this. And again, as long as everybody please realize we just want to get the information out there for everyone. We really don't want to, we're just trying to empower everyone with the information about the current landscape and the situations that everyone's in right now. Okay, I think Nadia's back here. There we go. Hey, you're back.
Hi. Yes. Awesome.
Okay,
so I did notice that some people raised the question of what if their hours are being reduced.
Mm-hmm.
So a similar concept applies where, you know, there could be a potential constructive dismissal there where the employer is making a substantial change to a fundamental term of your employment relationship.
Mm-hmm.
Obviously, it depends on whether or not the changes are actually substantial. So it's going to depend on a case-by-case basis. What we're doing with a lot of our clients and as well as certain dental offices is to make sure that people are actually including their agreement. So there's actually an agreement in place where people are accepting that their hours or their wages can be reduced.
Right. Which is, it's a difficult thing to agree to and accept, but these are also difficult times that nobody was ever predicting. And I know that there's no dental office I was expecting to have to shut down and stop treating patients because of a pandemic. So it was one of those things that even if you, I think we were discussing yesterday, if you have an employment contract and even as an employment lawyer, you said, hey, you should have a temporary layoff clause for pandemics in there. You think that's doesn't make any sense. That would never happen. So that's the tricky thing about these days is we're all trying to navigate this thing that we just all got blindsided with kind of thing and see how it kind of fits into the current structures of employment laws and things like that.
Yeah, no, for sure.
Do you mind, I'm just also kind of noticing a couple of comments to maybe just touch on people who might be considered temporary workers or independent contract workers, things like that, and maybe just, I know that's a different sort of playing field depending on how it's structured, but maybe can you touch on that a little bit? Have you run into that with clients in dental offices, questions about that?
Yeah, no, for sure. And I mean, we deal with this all the time in other contexts as well, but especially in the dental office context, where, you know, there are going to be some people who are an employee. There will be some people who are independent contractors, and I will only mention this briefly, but there's a huge issue with employees being misclassified as contractors as well. So just because you have a contract which says that you're an independent contractor doesn't necessarily, but employees are protected under the Employment Standards Act of Ontario, which
I think Nadia's cutting out again. Yeah. Do you know what though? And Nadia, I'll wait for you to kind of exit and jump back in, but we're getting close to the halfway mark, and I think that's when Stuart was planning on jumping to hear me and log back in. Maybe we can kind of finish off those thoughts, and then if Stuart's ready to jump in, we can kind of keep going with Stuart on there. Yeah, I wonder if it's, here we go. Hey, Stephanie, I see you. I see you wanting to jump in on the conversation too. I'll talk to you soon. I'm glitchy? That's just me. There. You're back.
Hi. Okay. Sorry about that.
No, that's okay.
I'm not sure what's happening.
I go, and so I was just saying we're kind of at the halfway mark. So should we just kind of finish off with the thoughts about the independent contractor, and then if Stuart's ready to hop on, we can do that.
Yeah, for sure. So I was just saying that with respect to employees versus independent contractors, the difference is that employees are protected. I mean, the main difference is that employees are protected under the Employment Standards Act of Ontario, and that provides minimum protections for employees. So if in the event that someone's an independent contractor, those same protections may not be applicable.
Right. And like you were sort of touching on just before it cut out there, there are situations where an employer and possibly an employee both wants it to be considered an independent contract situation, but with any deep analysis, it could turn out that any scrutiny would show that it's an employee-employer arrangement.
Exactly. And there could be significant liability in that respect. So sometimes people don't realize that it's actually not beneficial, and it doesn't necessarily matter even what the contract says. Like, even if the contract says that you're an independent contractor, you're actually an employee.
Right. And I think there's some good resources online about that, but certainly check with an employment lawyer. But I think there's, I'm going to say, a handful of criteria that sort of help separate out employee versus independent contractor in terms of their independence and what the situation allows for them to be considered independent contractors. I think there's sort of,
right.
Yeah, so that can help clarify that. Okay, any last thoughts? Anything else you want to say to everyone, or maybe even just a common question that you've seen in the last couple of weeks, or anything else you want to?
Yeah, so I do want to mention that the federal wage subsidy program, so the Canada Emergency Wage Subsidy, so qualifying businesses could receive a wage subsidy of up to 75% in order to help them keep and return workers to the payroll. So one of the issues we're seeing now is that because of the wage subsidy program, a lot of dental offices who otherwise, thought that they could just lay off employees are now considering bringing them back to work. So that's something that perhaps Stuart might touch on in his section, but we're definitely going to be grappling with these issues in the coming days.
Yeah, perfect. And I think, that was going to be my springboard into talking with Stuart about that, because I think, as we were talking about yesterday, it sort of might be this great connection back for offices that may not have laid off the team in necessarily the best way, sort of thing.
Right.
Yeah. Okay, perfect. All right. Well, thanks, Nadia. I'm going to, everybody, I'll close off with Nadia, and I'm going to try to add Stuart. Hopefully he's on in a minute or two. So, okay, thanks, Nadia. I'll talk to you soon, okay?
Thanks, James. Take care.
All right, bye. Let's see. Oh, there we go. So guys, I do see a lot of questions coming through. I have Ashley, who is our communications director. She is sort of jotting down questions. We're going to pass them on to Stuart as well at the end. And,
hi, James. I was going to turn my camera around. There we go. Hi, James. I'm good. How are you?
Good. Welcome, and thank you for your time for this.
Oh, no, thanks for inviting me, and thanks for setting this up. I've been following the conversation, and you got 160 people on, which is great.
Oh, wow. Yeah. No, and Nadia was a fantastic resource and great information too. And we were just about to touch on that idea of the wage subsidy and how that could apply for people who have been laid off. And we were sort of touching on maybe not. There were certain better and less good ways to have laid off a team, and the wage subsidy might be a way to sort of step back on that, I guess.
Yeah, I mean, step back is actually exactly what I wanted to do, because one of the biggest frustrations that our team has generally when it comes to employment law, not only in the COVID-19 world, is there is such a lack of information or so much misinformation out there. And the reality is most people make decisions without getting proper legal advice, and they expose themselves to risk. And we've been saying for years that, contrary to popular opinion, employers, i.e. dental practices, etc., don't automatically have the right to lay people off. And yet people always talk about layoffs, and if you look at the Employment Standards Act, it talks about how you go about doing it. People assume that you can. And that's what happened 2 weeks ago when everything started, and when the college made their announcement, and most of our clients that are dental practices either had to shut down or they've got skeleton staff operating, so they laid off a whole bunch of people, and not realizing that they don't have the right to do that. And as Nadia said, you can have that in a contract, and we've been recommending that for years, and we usually get pushback from clients who say we don't lay people off, and we always say keep it there just in case. No one ever
Right.
imagined this situation. But you've got this incredible tension over the last few weeks. I mean, look at what's happening. You've got dental practices that are either entirely closed or mostly closed, so they can't afford to keep paying their staff. And
Right.
at the same time, you've got people like us saying you can't lay them off. So something's got to give there. There's got to be a
Right.
solution.
Well, especially in
And
the long term. I mean, it's not, if it was a 2-week shutdown, it would be one thing. But if they're saying, the last thing from the Royal College was that offices won't be reopening in April. And so it's sort of so up in the air that you can sort of shut down for a couple of weeks and still keep people on the payroll. But given enough time, it's just not even feasible.
no, and that's the challenge. I mean, businesses are basically stuck between a rock and a hard place. That you can't afford to pay them, but you can't lay them off. So what do you do? And that's why, look, we're seeing every different level of government trying to find ways to help the situation, help employers, help employees. They know that everyone is struggling, and that's where this wage subsidy comes in. And initially it was announced as 10%, and it very quickly went to 75%, which is huge. And clearly the goal here is to avoid layoffs as much as possible. And I can say a lot of our clients have really, done a 180 in the last few days where they were going to lay people off, or maybe they already have. And they're saying, well, if it's only going to cost me at most 25%, I can afford to pay that for a while if that will keep the employee whole. And it's not even clear that you have to pay the other 25%. You may not have to. That's a little.
That's still okay.
Yeah. I mean, the wording was that they expect employers to do all they can to pay it, but it wasn't really clear as to how do you test that and what happens if they can't. I don't think they're going to insist that employers do, but I think they're going to be looking for some good faith. I think that's the bottom line.
Right. So, Stuart, if I understand what you're saying, is that by rehiring, if there's not a hard and fast obligation to even pay that, so essentially there's not a lot of downside to say, and correct me if I'm wrong, I'm not trying to put words in your mouth, but it could be interpreted in a way that there's not really a downside to saying, okay, you're all hired back, the government's paying 75%, I can't pay the other 25%, but at least that's more than EI? Is that an interpretation of what you're saying?
I think that's a pretty good one. I mean, that whole aspect about do you have to try to pay them is still, like we said, up in the air, but it sounds like if they're going to get 75%, whereas EI is typically 55%, and it's capped at about 400 or 550 per week, the employees are going to be better off, and of course they still got a job. And the other thing to remember too, and I do want to come back to this, but like we said, employers may not even have the right to lay someone off, but let's assume they do. And let's assume the employee agrees. And we've had a lot of clients, including hygienists and office staff, who've agreed to be laid off. There are time limits, and every jurisdiction has got its own legislation. So, we're based in Ontario, but we advise clients across the country. In Ontario, for example, it's 13 weeks. You can extend that if you continue someone's benefits, or there's other ways you can do it, to up to 35 weeks. But at some point, you're going to hit the end. And at some point, either you're going to have to recall them, or it's going to be a deemed termination, in which case you've got all your severance obligations. So even layoffs are not open-ended.
Right. No, that's a good point. And what we were saying too is, and what we touched on in our conversation yesterday was, it's sort of almost a olive branch to these dental offices that have done these layoffs, either if there was no employment contracts or if there was employment contracts that didn't have those specifications about temporary layoffs.
Yeah, I think that's true. And look, let's be frank, the vast majority of dental practices do not have contracts with temporary layoff clauses.
Fair enough.
So, all the layoffs we're seeing, unless they got the individual to agree, and that's a lot of how we're spending our time lately, at least until the wage subsidy, was we've been working with clients to work on agreements for layoffs. So, if we're advising the individual, for example, they might say, look, I'm willing to do my share. I know these are unprecedented times. I'm willing to accept a temporary layoff, but I want to be very clear that this is not a precedent for the future that you can lay me off, and I expect to be brought back as soon as it's viable. So a lot of times it's more of a discussion than an imposed layoff.
Right. Yeah. And now, what about, let's say the college says, okay, May 15th, dental offices are allowed to reopen. And there's even a conceivable world where they put specific limitations on how many patients a day, or how big your staff can be for that day, and things like that, to avoid crowding in offices and things like that.
Right.
But I guess in terms of bringing back partial of your team at some point, and then part of the team might remain on layoff, and what are some, I guess, how could that unfold, or what would be the mechanics of that, or things to watch out for, or a proper way to do that?
Yeah, I mean, look, the simple answer is it's not all or nothing. So you don't have to send everybody home at the same time. You don't have to bring them all back at the same time. So if in your example, you're operating at partial capacity, then you might make sense to bring some people back and not others. And there are no rules. I mean, we're not talking about unionized situations. I don't know of any dental practices that are unionized. If they are, they'll have a collective agreement, which would cover layoffs. And usually it's based on seniority. But for the otherwise, if there's no collective agreement, then you don't have to go by seniority or by any other logical analysis. You can pick and choose who you bring back, and as long as you're not breaching human rights. I mean, you can't obviously base it upon race or gender or things like that. And one other important point, which has been coming up lately, is you can't make a decision on the basis that someone has tested positive for or shown signs of COVID-19.
Interesting.
The Human Rights Commission has come out with a statement basically saying that COVID-19 will be considered to be a disability for the purpose of human rights considerations. Right. So, if one of your staff calls you and says, "Look, I've tested positive," you can't say, "Okay, good luck, but you're fired." That would be a very clear breach of their human rights. But getting back to what I was saying, other than those human rights grounds, you can pick and choose who you bring back. And I know, James, that one of the questions that was sent in a while ago, or that you were asked, was when it comes time to hire everyone back, what about if there are people I was hoping to get rid of anyways because they weren't great performers? Which I think is a really good question. So the simple answer is, I mean, you don't have to bring everyone back, like I said. You can have someone on a layoff and then terminate them. You could allow the layoff just to run its course when it will become a termination, or you could just terminate them now. But here's the important thing to remember, and I think Nadia may have touched on this a bit. If you're going to let somebody go on a without cause basis, you've got to give them either notice or severance pay. And there are so many myths out there. I mean, some people still think that the Employment Standards Act is all someone will get as far as severance pay, which is basically a week per year. That's not the case unless your contract says that's the case.
Right.
And again, and not to sound like to make this too self-promotional, but that's a lot of what we do. We help our dental practice clients draft contracts which say if we're going to let you go without cause, all we'll have to give you is your Employment Standards Act entitlements and nothing more. Right. So that can greatly limit your obligation. But if that isn't in place, then you have to give them reasonable notice at common law. And the myth we often hear out there is it's a month per year of service. And what our courts have said over and over again is that's not how the law works. And we're not only looking at length of service. We're also going to look at things like age, position, availability of similar employment. But to give people, I guess, a context here, the maximum in most circumstances is 24 months, 2 years.
Okay. Right.
So if you're talking about a long-standing employee, and I know most of our dental practices have long-term staff, long-term hygienists, if you're looking at a 50 and 20-year employee, I mean, you're looking at well over a year of severance in most cases. So you can let them go at any time for almost any reason aside from human rights, but there is going to be a cost involved.
That's a good point. Now, why don't we shift to maybe just the gray area of, so if about, say, and just like you had said, there will be an office, maybe they love everyone on the team, but maybe there's one or two people that they were thinking of not bringing back. But then from the other side of that coin, sometimes there are people who are working at an office that they don't want to work there anymore, and now they're on layoff, and they're using this as an opportunity to, when things resolve, to find another job or to send out the resumes or things like that. And we briefly talked about the gray area of when the dental office or the employer says, okay, time to come back to work on May 15th, and then how, if the person coming back to work doesn't necessarily want to come back to work, or says they're not coming back to work, and the implications about that for things like EI and severance and that kind of thing. And I know that's a big ball of wax, but just, I mean, some bullet points on that.
Yeah, I mean, once you recall someone from a layoff, it's essentially business as usual. So it's no different than if they were just working continuously, and if they just call in one day and say, "Look, I'm not coming back," uh, that's quitting. That's a resignation.
Right.
So if someone is, and you have to give them reasonable notice of the recall, but assuming that you do that, and assuming that there are no protected leave. So in other words, if they're not, ordered to be in self-isolation due to COVID, if they don't have protection because they have to look after a family member, you need to make sure there's no justification they may have legally for refusing to work.
Right.
Assuming that none of those things exist, then you're entitled to say, look, if you don't come back to work, we're going to take the position that you've abandoned your job, you've effectively resigned, and that's the end of your employment.
Right. And which, in those circumstances, I'm guessing it can compromise someone's ability to continue to collect EI afterwards, I guess, if it unfolds that way.
Yeah, that's a great point. So, I mean, EI is generally available when your employment ends, but there's really two circumstances in which it's not available. One is if you're fired for cause, and the other is if you resign. So, I mean, and it's an interesting situation as to how this would play out, because, of course, to get employment insurance, you have to have a record of employment, which is an important point to remember. A lot of people really freak out when they get a record of employment because they think that means they've been fired.
Oh, okay.
So it's important to note that a record of employment has to be issued in interruption in earnings, and there should be a record of employment. Doesn't mean you've lost your job. But here's the interesting thing in your scenario. So you've been laid off. So there's a record of employment issued, which indicates the reason being lack of work or shortage of work.
Yeah.
But now, 5, 10, whatever number of weeks down the road, you're ready to resume your business, and one of your staff says, "I'm not coming back." So technically, you should advise Service Canada that they've resigned. Technically, though, you're not really required to issue a record of employment because there hasn't been a new interruption of earnings. It's just the same interruption. Yeah. So I have to confess, I'm not sure exactly how that would play out practically, but once Service Canada is advised that someone resigned, they will not be eligible for EI anymore.
Right. And sometimes you had said, and I'm sure it's some kind of gray, but sometimes there's discussions around that between the employer and the employee about the actual nature of the ending of the work and things like that.
Yeah, and look, obviously you can't file something fraudulently with Service Canada, but there is a lot of leeway there, so there should be discussions as to what is going to be filed. Yeah. You just want to be careful. I mean, for example, we've had clients in the past who wanted to help an individual, so instead of filing the ROE saying resign, they wanted to file the ROE saying shortage of work. The problem with that is that implies a dismissal without cause, in which case you'd have obligations as an employer for severance.
Right.
So you don't want to put yourself in a situation where you actually have to pay severance, or the individual could turn around 6 months or a year from now and say, "Well, no, I didn't resign. You fired me. Look at what you put on the ROE."
Yeah, that's a good point. Now, in terms of, or do you know, or has the government put out the information in terms of the mechanics of applying for the emergency wage subsidy program? Is there a website, is there a resource in place that people can then get that, kind of pull the trigger on that and get that rolling?
Yeah, it's coming. You can't apply yet, but it's the date is available. And I'm actually just looking at my notes as we speak now, because things seem to change so quickly. So I've got some notes here. So they've confirmed that basically it's eligible from March 15th. They said it would retroactive to March 15th up till June 9th. They've also said, and again, they've talked about there's got to be a loss of revenue due to COVID-19. So they've said 30%, and you're comparing year over year. So in other words, is your revenue in March 2020 30% less than it was in March of 2019?
Right.
Now, I've heard that there will be some flexibility as to how you assess that, but that's the way they've packaged it right now. It's got to be that 30% decrease year over year. And as we talked about this before, the company's got to show they're doing everything they can to pay the employees, but what does that mean? We're not quite sure of. You apply through Service Canada. They've made that clear. They've said that the funds should start to flow in about 6 weeks.
Okay.
That might be overly optimistic. Right. Would not surprise me. I mean, the same way they were going to give us the details on Friday, and something like that became Monday and then Tuesday.
Right.
Wouldn't surprise me if it takes them a while. And remember as well, my understanding is they still need actually the approval of the cabinet to go ahead and do this.
Oh, I see.
So there may be some hiccups along the road, but I mean, the messaging has been very positive, and the messaging has been that they want to move as quickly as they can to help employers and in turn help employees because they know what everyone's facing. And it's interesting that what they've said is, if they're going to get the money flowing, and then if there's a problem with the paperwork, they'll deal with that later. Which, of course, is exactly the opposite of how the government usually works.
Right.
Usually, if you miss if you don't dot an I or cross a T, then the form gets sent back to you and you don't see any money. But the messaging is that this will be treated differently.
Yeah, nice. And I think because the government also, and everybody knows this will resolve, and at the same time, when it does resolve, nobody wants to be facing just a smoldering mess of businesses that have really just fallen apart because of this. And the government at least stepping up to support that, I think, is a really big step.
Yeah, and I think that the wage subsidy is a game changer to me. Like I said, we've seen so many clients who have just reversed their plan completely on the basis of the subsidy. I think the challenge now is, well, I guess a few things. Confirming how you show that you qualify with a 30% loss, but more importantly, implementing it quickly. And I know that some business groups have already, publicly stated that, this is a great idea, but their members can't wait 6 weeks or 8 weeks or whatever it is. They need the money sooner.
Right.
I do have a lot of sympathy for the government in this context because, I mean, they're doing this overnight, and you can't roll something massive like this with such a huge expenditure out so quickly. They're doing what they can, but I also have a lot of sympathy for our employers, whether they're our clients or other people, that they're struggling. I get that. So everyone is struggling, but this does seem like a huge initiative, which should make a big difference.
Yeah, great. Now, we've got about 12 minutes left in the hour. I'm just going to check through here. So we've got a question here, Stuart, maybe and I did notice this in the comments flowing through too. I saw CERB and EI coming back and forth, and then the difference between those two. What are those?
Yeah, it actually is very confusing, and Nadia and I were talking about this shortly before we came on to this discussion. It is very confusing. This is a lot of overlap. I mean, generally speaking, EI, I think we all know what EI is, and that's pretty clear. CERB is intended to help out and basically fill the gap. So I know Nadia mentioned really briefly that, for example, independent contractors, if you're a truly independent contractor, you don't get EI. Or for a lot of people who have their own dental practices, if you are the owner, you don't get EI.
You don't get EI, right.
And even if you pay yourself a salary, which of course a lot of people do for tax reasons, generally speaking, EI has arm's length requirements. So you're probably not making EI premium payments, but you also, on the other hand, you don't get EI benefits.
Right.
So there are a lot of people who will not qualify for EI, and that's what the CRB is intended to cover. Now, there are scenarios where people could be eligible for both. And the messaging so far has been very clear, don't apply for both. It's almost been like beseeching people not to do that. And what they've said is if you've already applied for EI, then just sort of leave it alone. They will kind of sort things out and into the right bucket, so to speak. At the end of the day, I don't know of any scenario where someone's going to get both. So they've asked people not to apply for both. But that's how we've been looking at it so far at a very high level is if you qualify for EI, apply for EI. If you don't, the CERB is really there for you.
Right, I see, okay. And I guess it probably depends on an individual's salary and things like that about whether the CERB is more or less than they would be getting from EI?
It can be. The CERB is a totally different calculation. So it can be. And that's maybe a scenario where you can sort of pick and choose a bit. But like I said, generally speaking, I think what they really want is the CERB is for business owners, independent contractors, people who don't qualify for EI.
Great. In terms of the EI, contract work. Just checking through, sorry. Take your time. Here. When do we start getting called back to work? Is there such things? A lot of these questions we sort of did touch on, Stuart. Yeah, I think we did a great job in this interview because I'm looking at these questions and we just happened to, I think, and I'm guessing while there's somebody saying about EI having trouble reaching the people at EI, I'm guessing it's flooded with phone calls and to be persistent about that.
Yeah, and I know that they've hired a bunch of new people. They've transferred people over from other departments. They're really trying, but they are swamped. We know that.
Yeah.
And one thing they've said is try to do as much as you possibly can online. So filing a record of employment, you can file it electronically. You don't need to send a hard copy. And for individuals applying for benefits, apply for a direct deposit, not check. That'll make it go a lot faster.
Right. Now, do you have any sense, and I'm just thinking out loud, for the wage subsidy, does it feel like would the government pay the dentist and then the dentist disseminates that money, or that the employees get a lump sum payment retroactive to March 15th? Or how do you think that will actually unfold in terms of the money flowing from the government into employees' pockets?
Yeah, my understanding, and again, I'm just looking at my notes here, but yeah, what we learned yesterday is that the funds will be paid to the employer, not to the employee.
Yeah.
And then obviously the presumption is that it will then be disseminated to the employee, and hopefully no one will take advantage. And there were some very strong words. It was interesting. I forget if it was Prime Minister Trudeau or someone else who talked about people gaming the system.
Right.
And I think that was the context of the 30% loss in revenue. But the point is, they're rolling this out really quickly. They want to get the money flowing quickly. They want to be able to help people as quickly as they can. But there was some very strong messaging about people taking advantage that, there will be consequences down the road.
Right. And I think that's a fair point, because they're doing what they can, and they're just saying, please don't take advantage of how quickly you're trying to help people, sort of thing, and do anything. Yeah. I think that's a fair point.
Sorry, I saw one comment float on the screen that they have a unionized practice. So I guess there are a few, but those are few and far between.
Yeah.
But if you are unionized and you're governed by your collective agreement, which almost every collective agreement talks about temporary layoffs, so you should have a look at that.
Okay, perfect. Now, I guess we're getting towards the tail end, but is there anything that I didn't ask you about, a message you want to get out, anything else you want to talk to people, or common things you're seeing from your clients these days that I haven't asked about?
Yeah, I'm just looking at my notes as well. I mean, I think the biggest thing is something I said at the beginning, but I'll say it again. I mean, it really frustrates us when people take action or make decisions without fully understanding their rights and their obligations. And especially in this context, when you look at the practice, the employer side, people need to cut costs. We all understand that. It scares us when we see people doing things to cut costs that may actually end up costing them more in the long run.
Right.
For example, the layoff. If you lay somebody off, great. So you've got them off the payroll for the next, let's say 13 weeks. But if they turn around and file a constructive dismissal claim, and as Nadia said, a constructive dismissal, if it's established, it's the same as if you just let somebody go outright. So, like I was saying a little while ago, if you let somebody go without cause, which you can do, you're on the hook for severance, and that can be a max of 2 years. So play this out. You just saved yourself 13 weeks of pay, but you could be on the hook for a year and a half, 2 years of severance.
Right.
So it scares us when people do that, and especially when they assume they have the right and then they take actions. And on the flip side, we've heard from a lot of individuals, and including a few hygienists lately, who were laid off, and they initially just thought, okay, well, I've been laid off, nothing I can do. And usually it's a spouse or a friend or someone who says, oh, maybe you should go see an employment lawyer. And in one case, I've heard someone said to me, I'm only here because my boyfriend insisted I come.
Right.
And I said, well, you really should thank him, because there was no legal basis for laying this person off.
Right.
And so we had the discussion. And as we said, it's not just because you have a legal right doesn't mean you have to enforce it. It shouldn't be a scorched earth approach. You don't need to blow everything up. But what you can do, and we've coached a lot of people through this, is to go to your employer and say, look, I got your notice of layoff, and the same thing would apply to a wage reduction, by the way. In my view, you don't have the right to impose that. I understand the situation we're all in. I'm willing to work with you, but let's agree on terms together, as opposed to you just imposing this layoff or this wage reduction on me.
Right.
So again, I think people are making decisions now without knowing their rights, without knowing their obligations. Our goal, part of the reason we do things like this, which I've really enjoyed our discussion, by the way.
Me too, yeah.
We do a lot of webinars. We put out a lot of information, and I guess I'll throw the plug in now. We've got a running blog on our website, all things COVID-19 workplace related. There was no point in doing a separate blog post every time something happened, because it would have been 7 or 8 a day. But we have a running blog. So if you go to rudnerlaw.ca, go to the blog, you'll see the COVID-19 running blog. Keep up to date and check out our social media as well. But the reason we do all this stuff, because believe me, we've been busy enough the last few weeks that we can take the time to do other things. But the reason we like to do it is to let people know what their rights are so they can make an informed decision. At the end of the day, you might make the same decision you would have otherwise, but at least you can go in knowing what your rights are, but also what your risks are.
Right. Really good point. And you know what also I took away from what you're saying too is, especially everybody's blindsided by this. Nobody wants COVID-19 going on, coronavirus going on, and the idea of just having open communication and not blocking each other off from the humanity of each other about what's happening. And everyone's trying to do their best, and everyone's trying to manage this surprise situation as best they can. And between employers and employees, the more there's an open dialogue, there's a more of a discussion, the more that there's an empathy for each other in their situations that they can discuss and come up with a way to everybody get through this together. I think there's real value in that instead of just adopting this immediate sort of position where I'm this and you're that and this is happening. I think there's real value just opening up those dialogues for everyone, because everybody wants their team to come back when they come back to still feel valued, to still feel engaged and enthusiastic about coming back to work and things like that. And there's certainly an opportunity in situations like that for that to deteriorate, but there's also an opportunity for it to be strengthened as well.
Yeah, no, you're right. And it's been interesting over the last 2 weeks because we've seen a lot of cooperation, a lot of spirit of collegiality. And like I said, we're not encouraging our clients to just come in and, with threats and, going and filing a claim the next day. We're encouraging our clients to work together. And so far, on both sides, there's been a lot of cooperation. It really helps when people see that everyone is chipping in, so to speak. So, we've had dentists go to their staff and say, look, we're going to have to cut your wages, but I'm taking a cut too. Right. And as long as people see that, it's not just, the workers who are being asked, it's management, it's the owners. Everyone is taking a hit. We're all in this together. James, you make a great point. This can actually strengthen the bonds as opposed to damaging the relationship.
I think so. I think kind of managed and led the right way. I think there's an opportunity for that. Yeah. David Geffen, notwithstanding, did you see his yacht that he was self-isolating on a yacht? You don't want to be a dentist that lays off your entire team and then sends photo from you self-isolating on your yacht on the ocean. That probably doesn't.
I didn't see that, but yeah, not the message you want to be sending.
Not really your finger on the pulse of society when you send that photo around.
No.
So, guys, if we didn't get to your question, which, to be honest, Ashley's been doing a great job of forwarding them to me, and I've been checking them on the screen here. I think we addressed most of them. We're going to review them once this is finished. We're going to be posting this video. So if you ended up tuning in later on and you feel like there was something you missed, we might have addressed it earlier on in the video. So we're going to be reposting the entire 1-hour video. We're also going to try to look at any questions we didn't address and maybe just give some point forms. There will certainly be some links and resources to contact Stuart and his firm for professional advice and consultation. And I'll just on our note, from a TempStars side, just so everyone knows, our team is still full steam ahead in terms of how we're building and going to be ready to hit the ground running for when this resolves. We're building out our customer service and our member support systems, and we're building a bunch of exciting new features because our developers have some extra time. So we are still full steam ahead on our end as well.
Excellent.
Yeah. So,
all right.
Thanks, Stuart. Yeah. So,
James, thanks for having us. I know we really enjoyed that. It was a great discussion. And like you said, if you can post a link to our running blog and the materials you put out. 100%. And I just encourage everyone to stay up to date, as I've been saying lately, stay safe and stay informed. And feel free to reach out to us. If we can help you, that's great. If not, then there's no harm done. But definitely better to reach out before you do something than try to fix it later.
100%. That's sleep well at night advice. When you have the proper I's dotted and T's crossed, it's certainly less stressful. That's for sure. It's worth the investment.
Yeah. Well, thanks again, and thanks everyone for tuning in.
Yeah, I appreciate it. Okay. Bye, everyone.
Bye.